What starts as a routine eviction hearing quickly spirals into a heated courtroom clash when a tenant walks in convinced she's found a legal loophole to escape unpaid rent. From the first exchange, she challenges the court's authority and insists she already paid, using special paperwork that the system supposedly doesn't recognize. The judge stays calm and asks for one simple thing: real proof of payment. But instead of receipts or confirmed records, she repeats confusing legal phrases and claims her documents are enough. As the pressure builds, the court clerk confirms that no money was ever received, and the opposing side points out that filing papers doesn't equal paying rent. The judge gives her multiple chances to explain how and when the payment was made, but every answer circles back to the same claim without any evidence. Frustration turns into anger, the courtroom atmosphere tightens, and what should have been a straightforward case turns into a dramatic meltdown. In the end, the moment exposes a hard truth: fake legal tricks collapse instantly when they collide with real courtroom rules and real-world consequences.
Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movement, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood, and that based on what I have submitted, that there would be a proper decision and ruling.
Okay, so I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, y'all.
Okay.
From my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity, I'm requesting that this motion under the titles, under the Rule 60B, that, this is thrown out. It just, we don't have a contract. There's nothing to really argue here. So, it's clearly displayed and stated in the affidavits that I submitted. And bottom line, we don't have a contract. The other entity does not own this property. I have priority interest and equity in this property.
Okay. Thank you, Ms. Ballard. As I said, I have had a chance to review the magistrate court file and the appeal materials that you filed in this case. One question I did have, Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put an affidavit to ask for rent. So, and there's no contract. But I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action, and the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment, or what did you file?
It is basically
Take a brief break for something. Hold on just one moment. Okay, Ms. Akpati and Ms. Ballard, I apologize for that brief interruption. Okay, so where we are right now procedurally is that there is a dispossessory order that was entered by Judge Brooks on December the 7th. Respectfully, Ms. Ballard, I don't, if you can provide me with some documentation of the payment, I'm happy to pursue that with the clerk of court and find out if there is some issue with it being credited to the wrong file or something like that. But absent any such documentation, there's no evidence that the required payment has been made.
So I tendered a payment into the court of registry. If my payment was not accepted, I would not have received a case number for this. It had to have been in order to get this case number.
Well, actually,
so I have to feel bad.
Actually, that's not correct. So the file indicates, Ms. Ballard, the file indicates that you submitted an affidavit of poverty, and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I tendered a payment in the magistrate court.
Right. I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment because there's no such payment reflected in the magistrate court. And so if you have a receipt, if you have a copy of the money order, if you have even a bank transaction indicating where you withdrew that money from, or where you obtained the money order, that would be some information that I could then go to the clerk and say, hey, I've got a party telling me that they made a payment and there's no record of it. Can you help me find this payment and why there's no record of it?
According to law, I tendered the payment, and I don't know if there's some type of mix-up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able. They even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right, can you hold one moment while I get the information? Thank you kindly. Yes, so let me just turn on my camera real quick. Okay, so
Yes, ma'am.
I filed a notice of tender payment into the court, and
the courtroom feels unusually tense before a single word is even spoken. A tenant steps forward with absolute confidence, carrying herself like someone who believes she has already won. There is no hesitation in her voice when she challenges the authority of the court. She claims that the judge has no jurisdiction over her and that the entire case is invalid because she has already settled the matter through paperwork she personally filed. To her, the case is not about unpaid rent anymore. It is about proving that the legal system itself is wrong. The judge listens patiently, letting her speak without interruption. When she finishes, the judge asks a simple, direct question: where is the proof of payment? Not paperwork, not claims, not legal-sounding language, but real confirmation that money was paid. The tenant responds by repeating that she submitted documents that count as payment. She says the court accepted them, and therefore the debt no longer exists. The judge asks her to explain what exactly she submitted, how much money was paid, when it was paid, and where the record of that payment can be found. Her answers drift in circles. She avoids specifics, falling back on the same claim that her documents speak for themselves. The courtroom begins to feel like two different realities colliding. On one side is a legal system that runs on records, verified transactions, and clear procedures. On the other side is a person who believes language alone can replace reality. The judge asks the court clerk to check the registry for any record of payment. The clerk confirms there is nothing there. No funds were deposited. No transaction exists. No receipt can be found. The silence that follows is heavy, the kind that makes everyone in the room aware that the truth has just landed. The tenant reacts by growing more defensive. She insists that the clerk is wrong, that the system is hiding her payment, and that the court is refusing to acknowledge what she filed. She claims the documents she submitted are legally binding and that the court is obligated to accept them. The judge explains, slowly and clearly, that courts cannot treat paperwork as money. A legal obligation is fulfilled by payment, not by declarations. The tenant interrupts, saying that the law has been misinterpreted for years and that her method of payment is valid even if the court refuses to recognize it. The exchange becomes less about rent and more about belief. The tenant speaks with the certainty of someone who has spent hours absorbing ideas from sources that promised easy solutions to complex problems. She repeats phrases that sound legal but collapse under even the lightest scrutiny. The judge gives her room to speak, then brings the conversation back to the same core issue every time: proof. The judge asks her to provide a receipt, a confirmation number, a bank record, anything that shows money was transferred. She has nothing to show. Each time she is asked for evidence, she answers with more words, more claims, and more frustration. The opposing side listens quietly, then points out that the landlord has received nothing. Rent is still owed. Notices were sent. The legal process moved forward because the obligation was never fulfilled. The tenant responds by accusing the other side of lying and participating in a corrupt system. The judge stops the back and forth and reminds everyone that accusations mean nothing without evidence. The courtroom does not operate on feelings or theories. It operates on facts. The tenant's tone shifts from confident to combative. She raises her voice, insisting that the judge is refusing to follow the law. She claims the court is violating her rights and acting outside its authority. The judge remains calm but firm, explaining that jurisdiction is established by the law, not by personal belief. The tenant refuses to accept this explanation. She repeats that she does not consent to the court's authority, as if consent alone can erase legal reality. The judge explains that legal obligations do not disappear because someone chooses not to recognize them. The courtroom atmosphere grows heavier with every exchange. Observers can sense that the situation is unraveling. What could have been a straightforward hearing has turned into a prolonged confrontation between established legal procedure and a set of ideas built on misunderstanding. The judge gives the tenant multiple chances to bring the conversation back to facts. Each time, the tenant returns to the same arguments, the same phrases, the same belief that words can replace proof. As the hearing continues, the judge explains the difference between claims and evidence. The judge explains that documents must be backed by real transactions. The judge explains that legal terms cannot be invented and then treated as binding. The tenant listens but does not absorb the message. She repeats that her paperwork is valid because she believes it is valid. The judge responds that belief does not create legal effect. Only lawful action does. The tension finally reaches a breaking point. The tenant accuses the judge of ignorance and bias. The judge warns her about respecting the court. The exchange becomes emotional, raw, and uncomfortable. The authority of the courtroom is challenged openly, not with evidence, but with anger. The judge explains that disrespect does not strengthen an argument. It only reveals the absence of one. The ruling becomes inevitable. Without proof of payment, the court cannot accept that the rent was paid. Without evidence, the claims collapse. The judge states the decision clearly, grounding it in the absence of any verified transaction. The tenant reacts with visible frustration, feeling wronged by a system that refuses to accept her version of reality. The courtroom returns to silence, but the silence is heavy with consequence. What unfolds in this hearing is more than a dispute over rent. It is a lesson in how belief can clash with reality. It shows how easily people can be led to trust ideas that promise power over systems they do not fully understand. It shows how dangerous it can be to replace evidence with confidence. In the end, the court does not respond to theories, no matter how passionately they are argued. It responds to facts, records, and lawful proof.
To the courts, and I'm sure you can see the affidavit in there, and it has proper endorsement. It's been properly endorsed. And if you like, I mean,
Ms. Ballard, can you tell me the case number on that? Is it this case number 2023 CV 390-111, or is it the 23 ED 284322 case number?
It's 23 ED 284322.
Okay. Give me a moment to look in the file and see what I can locate. Okay. Give me just a second.
Thank you.
Okay. Thank you for your patience as I've sort of worked through this. Ms. Ballard, Ms. Akpati. I was able to locate the filing that that Ms. Ballard was referencing, which is a notice of tender of payment to settle and close account.
Yes.
And is that the thing you were referencing, Ms. Ballard?
Yes. Yes.
Okay. That was filed. It was filed in the magistrate court on December the 12th.
Yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court, and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be any like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy this. You instead submitted some sort of signed, some sort of authorized representative document, but no money order, no check, which I don't think they take, no cash, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed, Ms. Ballard?
I filed a tender payment, and it didn't, I mean, the law says that I can tender a payment. It never stated how to pay it. So, I mean, I fulfilled the contract based on the order. I mean,
Ms. Akpati, other than the motion that you filed regarding the lack of payment and your statements here that there has not been a payment, what is your position on behalf of your client on this matter?
Our position is that this matter should be dismissed. Ms. Ballard has to comply with the order of the court before filing this appeal.
And so I have reviewed what you filed now that I understand what I was supposed to be looking at. And, due respect, ma'am, but it is not filing a paper that says I hereby tender payment that is not actually accompanied by a payment recognizable in legal acceptable tender in the United States. Then you have not made a payment under any legal definition that I am aware of. And so as a result of that,
excuse
me, Ms. Ballard, I'm speaking, and in a moment, I'll let you respond.
On the order, it did not specify how to pay. What species of payment is on there to pay? It was not specific.
I'm sorry, are you saying it wasn't specific in amount or it wasn't specific in method?
In method, yes.
Okay. I disagree. This is a standard order, and the vast majority of everyone I've ever dealt with that deals with these orders understands that when it says tenant must, in capital letters, make the following payments into the court registry by the time specified, everyone understands that I've typically dealt with that means money that is recognizable as legal tender in the United States. Which would either be cash or a money order or a certified check. And in the absence of those things being paid, then the court wouldn't have any choice but to dismiss the appeal. And so
I gave you a bill of exchange, which is the same thing.
I'm sorry, ma'am?
I gave you a bill of exchange, which is the same thing.
No, ma'am, it's not. A bill of exchange is not recognized as legal tender in the United States, and therefore it would not satisfy the requirement that tenant must make the following payment into the court registry.
Will you be so kind to confirm under what law?
For that reason, I am dismissing case number.
I mean, ma'am, I object. I object. I mean, it's there. Under what law does it say that it is not a legal payment, a legal tender?
So, in all honesty, I don't know the answer. I could do some research and find the answer, but Ms. Ballard, it's your obligation as the movant to provide the information that the court requires in order to understand your case, to accept your case. And you have not provided me, more importantly, with any documentation or a legal citation that would provide me with some sort of basis to accept your providing me with this note of exchange as legal tender. As I said, my understanding of the law is that a note of exchange is not legal tender recognized in the United States, and therefore it does not constitute a payment.
You have not provided me an answer. But under what law?
Yes, ma'am, I did. The answer I gave you was it was your obligation. Mr. Freehouse, please,
ma'am, I need to finish what I have to say. I
Mr.
need to-
Freehoff,
how
please
can you
mute Ms.
make-
Ballard
how
if
can
she's
you
going to
make a
continue to
ruling?
speak over me. Thank you. Ms. Ballard, you've been muted because you continue to speak over me, which is disrespectful to the court.
I'm not
Okay.
trying to be respectful. You're
Ms. Ballard,
interrupting me and not properly.
you are
giving me due
continuing to
process
speak, and Ms. Ballard, stop. I understand that you do not like the outcome. I understand that you believe that that legal tender or notice of exchange that you gave me should count, but it does not. The answer to this question is that the order that was entered says that tenant must make the following payments into the court registry, and there were no payments made into the court registry, and the filing that you submitted does not constitute a payment of legal tender into the court registry and does not constitute compliance with the order that you make a payment into the court registry. And therefore, the case is going to be dismissed. Case number 2023 CV 390111 will be dismissed for lack of payment. Anything else that the parties need? Ms. Ballard, you may pursue whatever appellate rights you wish to pursue.
You cannot make a
Obviously, you
ruling over
disagree with
something
my
that
order.
you don't know.
I'm sorry, Ms. Ballard.
You
I
cannot make
did
a
not hear
ruling
you.
over something you can't know. You saying you don't know is an unacceptable response. Respectfully.
Ms. Ballard, as I said, my answer was, if you would like to direct me to case law that says that what
Is
you
this a
submitted
court of
is
law?
legal, Ms.